SJC-13212, Commonwealth v. Timothy M. Roderick.
Okay, Attorney Crane.
Good morning. May it please the court, Edward Crane on behalf of Timothy Roderick. The threshold question here is whether it's the Commonwealth burden to prove the reasonableness of GPS monitoring. In Feliz, this court concluded that GPS monitoring constitutes a warrantless search. It is well established that the Commonwealth bears the burden of proving the reasonableness of a warrantless search. Thus, it must follow that the Commonwealth bears the burden of proving the reasonableness of GPS monitoring. The Commonwealth itself appears to concede this point, as it makes no argument to the contrary in its brief. The next question is whether the underlying facts of the defendant's conviction can be relied upon to support the imposition of GPS monitoring in the absence of evidence linking these facts to an increased risk of recidivism. In Feliz, this court made it clear that the reasonableness of GPS monitoring depends on the defendant's risk of reoffending. Thus, if the underlying facts of the offense—
Why do you say that? In Feliz, we say the absence of evidence demonstrating risk of recidivism related to the defendant tilts the balance against concluding that GPS monitoring is reasonable under the circumstances. Why is recidivism dispositive in an individualized determination of reasonableness when at the same time you reference in your brief, and I believe in Feliz, that we're dealing with a constellation of factors?
Yes, I think the constellation of factors, though, go to the risk of recidivism. So there should be a constellation of factors that are considered when answering the question of whether the defendant—
But how could that be if the absence of the demonstration of recidivism only tilts the balance against GPS monitoring? And why aren't many other factors also in play? And I think you're about to talk about the information about where the alleged victim lives and whether or not that's a permissible factor. But putting that aside and just asking as a general matter, protection of the alleged victim pre-trial, for instance.
Yes, I think that well, the factor protection of the victim, I think, it would certainly be a factor that could be considered, but it ultimately boils down to, again, recidivism, because the level of protection that's required ultimately depends on the defendant's risk of recidivism.
Isn't it kind of a chicken and egg thing? Because if the defendant visits the victim, they've committed a crime, and that's recidivism, right? So we're protecting the victim from the defendant, or trying to— that's a reasonable goal of these monitoring, correct? You would agree with that?
Yes.
Right. So it's kind of semantics, isn't it?
In some respects, yes, but I believe that ultimately in this situation, the offense has been committed. So
right. No, but the point is, you know, I think Feliz was a great case for the defense to bring, because it was some person viewing child pornography in their basement. And there was, right, and that was a perfect case of challenges. Now, the next challenge, which you appropriately bring in a case, is where there's a live victim, and whether or not in every case where there's a victim, do you get GPS monitoring? I think that's essentially the issue. Does that tip the balance to reasonableness?
yeah, and Your Honor, I think that that's a great point. Feliz was on one end of the extreme, and this case, I would say, falls— I don't think it's on the opposite end of the extreme, but it's somewhere in the gray area that exists, because there has been no—
And we've cut you off twice, but give us the point of, well, why it's not reasonable to exclude this, have an exclusionary zone from where this person lives, the victim.
Why it wouldn't be reasonable?
Right.
Well, ultimately, the reason that GPS monitoring wouldn't be reasonable in this case is because there's no evidence that this defendant is at risk of reoffending.
He's a level 2, correct?
Right.
He is a level 2, correct?
Right.
And but I would contest that that's really the only factor that the Commonwealth has put forward with respect to his risk of recidivism. And I don't think that that can carry the day for the Commonwealth.
Yeah. So first of all, we can't say no, because it is level 2 for whatever that adds. But why can't the underlying allegations be a factor? The defendant's alleged rape when the alleged victim had no ability to consent. What does that tell us perhaps about possibility of recidivism?
I don't know. And I think that's ultimately the what's lacking in this case. If the Commonwealth can put something forward that says defendants who take advantage of victims who are intoxicated or unconscious, that suggests a level of recidivism that increases the likelihood of recidivism, then that factor would be relevant.
Well, what's the point of a stay away if you can't enforce it?
Right. Which actually makes no sense, right? Because that was the thing where people would ask for stay away orders and say, okay, will you point your finger and say, stay away from that person? Stay away from that area. I mean, without a way to enforce a geographical limitation or without a way to say, stay away from a particular person, how would you enforce that?
Well, the enforcement mechanism is ultimately through the court. If the defendant is
Right, that's what
Right.
that's what the GPS does.
And that's where those Elmo notes come in and the maps come in and say, look, there it is, right there.
But I would assert that stay away orders are instituted every day in the courts throughout the Commonwealth that don't involve GPS monitoring. And those orders can still be effectively enforced through, if the defendant violates a stay away order, whatever evidence they had that he did that, go to the probation officer, go to whoever's responsible for supervising the defendant and report that. So, I mean, I think it's a stretch to say that if stay away orders have no value whatsoever without GPS monitoring, then it seems like, you know, in every district court in the Commonwealth, there's stay away orders that are issued every day without GPS monitoring. We shouldn't be doing that.
But this isn't the this is a rape though, right?
Right.
Isn't that different? It's not the typical case that comes in where there are witnesses, the person that's the clerk at the store where they shoplifted from. Stay away from the store. Okay, fine. But this is a rape. Isn't that different?
Again, I think what I would say is that I'm ultimately there's a lack of evidence here with respect to whether does that make a difference? Because it's ultimately what the point of the GPS monitoring is, to make sure that this doesn't happen again. And if there's no evidence as to whether someone who commits the offense of rape is more likely to reoffend than someone who commits, say, the offense of armed robbery at a convenience store, it ultimately, there has to be this link between the offense and the risk of recidivism.
Do you think there is a difference in the circumstances of different rape cases or rape charges, so that an aggravated rape might be different than a rape?
Absolutely.
And how would that manifest in explanation with regard to the GPS condition?
I think with respect to a more aggravated case, there's going to be underlying facts there that the Commonwealth can easily point to that scientifically have been proven to increase the risk of recidivism.
What do we do with the fact that for the SORB hearings, right, they have a list of factors, and one of the factors is taking advantage of a victim who is, in this case, altered, and that is a factor that SORB considers in setting the level 2. Isn't that enough for the Commonwealth to satisfy its burden? The fact that it's already been, social science has shown that this is an aggravating factor, and that's why it ends up on the list that SORB uses in setting whether somebody's a level 1, 2, or 3.
I think at this point, procedurally, I don't think it's appropriate to rely on the SORB factors when they weren't discussed below, they weren't relied upon by the Commonwealth, they weren't discussed by the judge. Certainly, I think the SORB factors are based on scientific evidence. So if the Commonwealth were to go back and say this case was remanded and the Commonwealth introduced the SORB factors and sort of the science behind that specific SORB factor, certainly that would be a factor that would support the reasonableness of GPS monitoring. I think why it can't be done here is it wasn't introduced at
The
the,
judicial notice of the SORB factors?
I think the court can take judicial notice of what the SORB factors are. I'm not sure that the court can take judicial notice at this point of the underlying scientific studies.
Mr. Crane, how have these Grady hearings borne out with respect to named victims? I know you looked a little bit at this. Can you tell me more?
Surprisingly, there's not as much, there hasn't been as much litigation as one would expect in these cases. And I mean, just anecdotally, what I might suggest is that the reason we're not seeing as much litigation with respect to offenses involving victims is the defendant often is still serving the sentence, and the defendant is, there's no incentive.
Because Grady's so new, essentially.
Essentially, yes, Your
Right.
Honor.
Okay.
Likely waiting till the end of the sentence to challenge the GPS monitoring. But there really hasn't been many cases. There's a few unpublished cases from the appeals court involving contact offenses, but compared to this case, much more serious offenses, and in I think the majority of those cases, evidence of compulsive behavior, repetitive sexual offenses.
I thought the two factors that were most helpful to you haven't mentioned, because you're fighting an uphill battle on, he's a level 2 and it's a rape. But the two things that are best for you, I thought, were one, she has no address, right? She seems, so that what the GPS is going to do is a little unclear. Am I wrong on the facts on that? Does she have when they put the GPS in place, does she have an identified address, or is she still sort of homeless and moving around?
Well, at the motion hearing, there was no evidence that, really the evidence was that the Commonwealth was not aware of the victim's address.
So this isn't one where we can say, okay, here's where she works, or here's where she lives, and a GPS can provide us protection in that respect, right? So that, or I'm just trying to help you out here for a second. Is that right?
Yes, I should note after the fact, the Commonwealth has moved to expand the record with evidence that it has an exclusion zone.
Okay,
around it.
so she lives a half a mile away. Why can that not be part of the reasonableness analysis at this point?
Again, the position of the defendant is that this had to be introduced at the time of the motion hearing. I mean, it's much like a motion to suppress, where the Commonwealth has its burden to satisfy, and can't sort of after the fact establish its burden through expanding the record.
Didn't Judge Locke have those same questions and they got answered to his satisfaction?
We never went back in front of Judge Locke after the fact, after this motion hearing.
So it was only the one hearing in front of him?
Yes, when he ruled on the motion at that point in time, there was no knowledge of where the victim, there hadn't been.
I thought he had
established where the
said supplement this or give me some more information. I thought that was part of the hearing.
There was talk of doing that, but it ultimately didn't go in front of him.
So when Judge Locke does this, he doesn't know, does she have a place of employment? I mean, is she employed or housed when the GPS, because the two big purposes, right, are to keep you away from the house and keep you away from the work, right?
Yes,
Is she employed or homed? Does she have a home?
I know now that the Commonwealth
I'm just talking about the record before the judge, not what we, because that's
record before the judge did not reflect either a residential address or a place of employment.
so the two things that go for you are that, and that it's sort of a crime of opportunity. She's sleeping in his chair, and he has no other record of any other sexual offense, right? He still gets a level 2, but there's no other record of any sexual misconduct. Is that right?
Yes,
So those are the two factors we've got to weigh in your favor, because otherwise you're running up a mountain. You got a rape, and you got a level 2.
yes, Your Honor, I would say the factors, you've pretty much covered it, but the factors that would support the defendant's position here is the lack of criminal record. It's not just that he.
And that the GPS, it's not clear exactly what the GPS is going to do.
Yes,
Mr. Crane, I found what I was looking for. In the motion here in front of Judge Locke, you say, I'd ask for a motion to reconsider if there cannot be established an address for the victim. So basically you put the burden on yourself for that. And the court said, well, there's a concern. And if there's no meaningful exclusion zone, I'll hear you later. And then nothing happens, correct? Is that?
yes.
So you answered who has the burden of proof. What is the burden of proof?
The burden of proof is simply reasonableness.
But by a preponderance, or what do we?
It's always difficult to define reasonableness, but I think it's reasonableness ultimately. The facts I think would be determined by a preponderance of the evidence because this is, again, it's essentially a
The
suppression.
reason I ask is because the SORB burden of proof is by clear and convincing evidence. And if SORB has concluded that it's a level 2, why isn't it meeting the Commonwealth's burden to rely on the level 2 if the burden here is by a preponderance?
The main problem with simply relying on SORB's classification is it seems totally counterintuitive to what the court said in Feliz, in which it said there has to be individualized hearings, and also that mandatory imposition of GPS monitoring on a large swath of the population is improper. If the trial courts could simply say, you've been classified as a level 2, that means GPS is reasonable. It seems to be doing exactly, or taking out the individualized assessment and also really imposing that mandatory GPS on a large swath of the population. So it just doesn't seem to comport with Feliz, the relying simply on the SORB classification. And it seems like this court would have, if that was the case, this court would have said so in Feliz and saved trial courts a lot of time if that classification level could carry the day for the Commonwealth.
Okay, thank you very much, counsel.
Thank you, Your Honor.
Attorney Black.
Good morning, Your Honors. May it please the court, Johanna Black for the Commonwealth. Now, protection of the public, punishment, and retribution are all valid goals of sentencing and probation.
But before you really get into that, it would help us know what we can and cannot consider. So
Sure.
why can we consider where she lives now?
Why can you?
Yes.
If you read through the motion hearing, Judge Locke operated under the presumption that the victim had an address that would be put into Elmo. And I think where the law supports the presumption of regularity and certain things like that, Judge Locke was entitled to presume that there would be an address, a residential address obtained and put into Elmo. And he did, as Justice Gaziano noted, put it on the defense when the defense made the argument that if an effective exclusion zone couldn't be entered into Elmo, then that would affect the analysis. Judge Locke gave the defendant the opportunity, if that were to arise, to come back.
I mean, it's a question, it's not a rhetorical question, but how does the defendant do that? So the burden's on the proof is on the Commonwealth, right, to prove this. How does he know where the victim, who's someone who moves about, lives? I mean, he obviously knew her when she was living in his chair, but it's a little different after he's been convicted.
Well,
of
presumably when he's
raping
released
her.
from
How does-
incarceration.
how's he gonna know whether she has a home address or not? Isn't
Well,
that
leading up
really,
to-
isn't that really the responsibility of the Commonwealth?
And the Commonwealth obtained it and gave it to probation, and probation obtained it.
But do they give it to Judge Locke?
No, but I think Judge Locke presumed that if the issue weren't brought back beforehand, then there wasn't an issue.
Just weird. I mean, I'm not saying it's wrong. I'm just saying it's odd.
Well, oftentimes there are exclusion zones that are entered, and the judge who's ordering that exclusion zone doesn't know the exact address that the exclusion zone covers
Right,
because,
but we do know, in this case, we know the reason she's living with him is she doesn't have a home.
right at the time of the offenses.
But there's a sort of a history of kind of homelessness, isn't there here? I mean,
There was.
It just makes it harder. It makes it a more difficult case because it's not clear what the GPS is doing.
Right. Well, I would argue that the defendant would have been put on notice leading up to, or at least if not leading up to, by the time probation's working with him to put the GPS on him. Upon his release from incarceration, he would know whether there was a valid exclusion zone or not at that time.
So you're saying he has to wait to find out if the exclusion zone is valid?
No, I think just in this case, that the evidence before the judge, everyone was operating on the presumption that the address would be obtained, that the Commonwealth just didn't have it at that time. And I mean, I realize that it's a Commonwealth's burden to prove reasonableness, but I do think, it's something to consider that the defendant, instead of saying, look, she has no address, was just saying when the Commonwealth notified the court that they couldn't represent that they had the address at that moment, that the defendant kind of acquiesced in, if there is an issue, I'll bring it in front of the court. But another part of the Commonwealth's argument is that the GPS in this case wasn't reasonable solely because of the stay away order and the exclusion zone that have enforced that. It was also reasonable because the victim's well-being or state of mind is a significant consideration. And as the Commonwealth argued, she's entitled to some sense of security, at least for some period of time after she's been raped. And that's what the ADA argued to Judge Locke during the hearing. The court has already, in case after case, promoted the goals of punishment, protection of the public, and even retribution in sentencing. And
That's sentencing, not probation though, right?
probation's protection of the public. That's the primary goal of probation. And in fact, this court in the Corey case that I cited, talked about the act that.
But what about the other two leading? Retribution, is that part of probation?
I think the fact that in Corey, this court talked about
Yeah,
section
where
47.
Where in the Feliz case do we say part of the reasonableness is a little old fashioned retribution? Is that in
Well,
Feliz?
the Feliz case is an opposite to this issue. In
I
Feliz,
thought we were here for Feliz issue.
well, that's what the defense made the issue about. But
This
this
is whether or
case
not you
is-
can put a GPS on someone for probationary purposes.
right, and in
I
Feliz,
thought that's what we said in Feliz, but go on.
right, but that was pertaining to a different set of facts and a different crime. And in Feliz, the Commonwealth was arguing solely that GPS would have a deterrent effect and that GPS would help gather information or evidence as to whether or not it was the defendant, in that case, Feliz, who committed a crime that arises. Here, the Commonwealth's arguing that just the victim's well-being, the protection of the public. I mean, you harm a victim, you're harming society. Anyone who deals with the victim has seen the suffering that they've gone through. And that affects not just the victim, but everybody that victim
All
comes
right, so
into
counsel, I
contact with.
understand that. Can you explain, as if I were your grandmother,
Mhm.
what this exclusionary zone accomplishes for the victim?
Sure.
Like, or could you just explain to me, as if I'm a layperson, what is the defendant not supposed to do? Just tell me what he's not supposed to do.
Well, an example of what he's not supposed to do is to come
But what he's
into,
not supposed to do pursuant to this GPS condition. What is it restraining him from doing?
right, if he enters the exclusion zone that
Okay, where's
surrounds,
the exclusion zone?
surrounding the victim's residence.
And we don't know where she lives in the record.
We do. I'm asking that Your Honor consider the probation documentation that shows it when he was released from incarceration and the GPS was put on.
And assuming we had a valid address and we have an exclusion zone, do you differentiate anything among the kinds of crimes involving rape or involving any other kind of assault and battery or harm to a person? Are there differentiations among them in terms of when a GPS should be used, or should they just always be used in all cases to protect the victim?
No, I think the facts matter. I think the type of crime matters.
What facts would you say matter here?
I think the fact, well, not that we need it, but there is a risk of recidivism. But I think also that the facts of a case or the underlying offenses, if they show a dangerousness or a significant danger posed by the defendant, the risk of reoffense becomes less significant because even if they reoffend once.
What in the record shows a risk of reoffense or a risk of or a danger to the victim in the future?
Well, so
if you're not saying, because you're not saying all people charged with rape require a GPS to protect all victims.
I don't think we have to say that in this case. And that's the Commonwealth would be concerned about making blanket rules.
But you do agree that there has to be something about the crime and something about the defendant that justifies the GPS.
Right, yes.
So
it has to be an
in
individualized
In
determination.
this case, other than the fact that this was a rape inside his home with somebody he knew when she was unconscious, what about that fact pattern says we better put a GPS on this one?
What about that fact pattern?
Yeah.
The fact that, well, it was penetration and that creates significant psychological harm to
Well,
a person. So
I'm
that-
going to concede she's significantly traumatized by this situation.
Mhm.
I want to know how putting a GPS on this defendant precludes further traumatization of her.
Sure. So where he raped her when she was unconscious, the fact that an exclusion zone would be placed around her residential address allows her,
But you
hopefully,
don't
to
know
go to
her
sleep at
residential
night.
address in the record,
We do.
but not in this record. You have a motion in front of us, right?
Sorry, I'm just trying to answer your question. I thought you asked me what the exclusion zone would do
Well,
for the
I
victim.
want to know what it is if you don't have an
So it
address.
allows her to go to sleep at night. She's been raped while she was unconscious, asleep, drunk,
We
and
agree
helpless.
we agree with you. The crime's heinous and there's trauma to the victim. We're trying to figure out practicalities here. Particularly, it sounds like this is not an uncommon situation where you don't know where someone lives when you're doing this. Or maybe you do. I don't know. That's the sort of, the difficult issue here is timing. We have someone who has a history of homelessness, but the judge may have been under the correct assumption that she had a residence at the time, but we have no evidence of it until after the hearing. And then the burden of proof is on the Commonwealth, but the burden was actually put on the defendant. So it's kind of a murky, right? So we're trying to figure out how to avoid this going forward rather than, talking about the trauma, which we totally agree with, and the heinousness of the crime, which we totally agree with.
Well, I think in the trial courts, oftentimes things are moving quickly and maybe the trial court judge is considering, a faster resolution of this issue, a faster decision on my part might aid the defendant. So I think a trial judge is juggling and kind of working with what they have in the moment. I mean, the hearing arguably could have been continued until the Commonwealth ascertained the victim's address, and then the judge would have had it right in front of him, and this wouldn't even be an issue. The defendant wasn't even released from incarceration yet. He wasn't supposed to be released until July 9th, so they had 3 weeks.
Right. The
But-
issue in Felice, even though you don't think this is a Felice case, is the search has to be reasonable. That means it has to further a governmental interest versus the privacy concerns that we articulated. And that's what Grady says, that putting a GPS on someone in probation is a search. One of the factors we are discussing is the recidivism and whether or not he was a level 2. Is that before us or we discard that?
I think it's something for you to consider. I don't think, I think there are two individual categories or grounds that this court can rely on. The fact that the victim's well-being is important and that, a recidivist always starts out with one offense without any history of prior offenses. And if you were to say, and well, there's no evidence of recidivism because he's never violated probation or he's never violated condition of release. Well, if he reoffends, you've created another victim out of society, and there's more evidence that he's recidivating. So I don't think
So
a
is the
history-
default is any first-time offender is a recidivist because we don't want to take the chance, and so
no, but
GPS is allowed even though it's unconstitutional otherwise? I don't
no, but
get
I'm
that.
saying you can't make a blanket rule on the opposite end of the
No,
spectrum.
but I know, but there's constitutional rules putting a thumb on the other side, as we see in Feliz and Grady. So the burden is on the Commonwealth to show that whatever the individualized assessment of this particular defendant justifies as reasonable the GPS. You seem to be suggesting that everybody starts off with one offense, and so therefore, what?
No, but I'm saying it's something to consider. I think in Feliz, the recidivism was a factor and an important factor because it was possession of child pornography. The person here committed a contact offense, already created a victim, and it's a victim's well-being, which wasn't considered in Feliz. I mean, there are victims in child pornography, but here you have a victim who and is suffering. And so the victim's well-being, if you want to protect the public, you should be protecting the victim from being re-victimized every single night.
Has that ever been considered in the governmental interest in the Feliz Grady balancing the victim's well-being?
So I'm glad you brought that up because in Grady and Feliz, their arguments were about recidivism. This is not, as I'm trying to point out, it's a separate concern, the victim's well-being. In Feliz,
Right.
they weren't.
The question I asked you is, has this as a governmental interest to overcome the privacy interest, has this ever been articulated by any court anywhere?
Yes, I think so. I think this court in Corey, when they were talking about the act that Section 47 was a part of, they were talking about the fact that the
Sorry,
legislature.
Which case?
Sure. It's cited in my brief. I just want to grab. It's Commonwealth v. Corey.
I'll find, if it's in your brief, I'll get it. Don't
Thank
worry.
you.
Don't waste your time.
And so in Justice Ireland's dissent, he's noting that Section 47, which is what this whole issue has stemmed from, the fact that Section 47 is tying the GPS requirement to the victim shows that the legislature's concern was protection of the victim. And in Guzman, this court talked about how the legislature may establish harsh punishments to discourage reoffense. And in Corey, this court, again, was talking about GPS promoting traditional aims of punishment and goes into deterrence and retribution. So Corey itself is bringing up the fact that retribution is an important consideration. And that was a GPS case as well.
You don't really want us to rely on retribution for a GPS, do you? You don't want us to.
Not always, but I think it's a consideration. I think the
Really?
victim's well-being
Just
is
seems
important.
crazy. That just seems
Old
way
Testament.
out there. Yeah. I mean.
But
we-
it's
we gotta-
there. It's a
We got to
valid.
decide whether the GPS is serving a purpose. You got a lot of reasons why it may very well be serving a purpose here, but two of them have to do with the fact that she's got an address or a workplace and that he's a level 2. Those seem to be two important factors to the trial judge in putting the GPS on, right?
Mhm.
And by the way, if they seem legitimate, but Mr. Crane argues that all we have are the factors. We don't have the actual underlying data. I don't know if we need it, but I don't know. It just seems like we don't need to go to retribution. And this is a classic Feliz case. It's the next Feliz case. So.
Well, I think Corey, this court already talked about, you can consider dangerousness or risk of reoffense. So I think a person's degree of dangerous when it's So I think this court has already said you don't need a risk of reoffense inquiry, is my point, when it's saying you consider
Corey was
dangerousness.
a post-Grady case.
No, I don't
An
think so.
early case. So
I think
Corey
it's
is a,
earlier.
Corey is a, Corey is a
Right, it's
19,
earlier.
2009,
Yeah.
right?
2009. case.
But it's discussion of the goals and objectives of sentencing and probation still are valid, and something to be considered. And I think, the risk of reoffense drops, the significance of it, I would say, drops when the danger posed by any risk of reoffense is higher. So I think it's, like this court has said, it's a balancing, and risk of reoffense isn't the end all be all. In Feliz, it was more significant than it might be in other cases. And the Commonwealth's position is in this case where there's a victim and GPS would enforce the exclusion zone while she's sleeping, and the prime target for the defendant, her well-being and sense of security and sense of safety would be restored. Hopefully, it would at least help in restoration of that, for her to know that he's being watched, he knows he's being watched, and there's an alert that's going to go off if he comes in within half a mile of her home.
Which we don't know on the record.
Right.
Okay, thank you, counsel.
Thank you.
Got it.